All right, folks. I'm Greg Siskind. I'm joined by Adam Cohen, and hopefully in a couple minutes we'll be joined by our friend Andrew Rankin, who has a different type of immigration practice, but I think is going to have some helpful things to talk about. I see Andrew now. Let's chat him in.
There he is. Oh.
Control.
We got it.
Hey, Andrew.
Hey, Greg. Sorry about that. The other link. Apparently, I had to completely log out.
Right.
Don't worry.
Don't talk about behind the scenes because you're live. All right. So this is a regular Wednesday night live stream, but this time we're going to talk specifically for the whole hour about student visa issues. And I'm really glad that I'm joined by both Adam and Andrew. Adam is a nationally known expert on student visa issues. He writes the Academic Immigration Handbook, which is the book that is distributed by the American Immigration Lawyers Association to its members.
Not quite yet.
All right. Very soon. You can still get your hands on the book, though, I think, on Amazon if you really want it before ALS selling it. Adam is a regular speaker at National Association of Foreign Student Association events, at ALA events on all things university immigration related. Andrew, I don't know if Adam, if you want to introduce Andrew.
Yeah, I would. So I've known Andrew for many, many years, and Andrew is very, very well known in the removal defense space, especially working in immigration courts. And he's worked for years, first as a paralegal and then later as an immigration attorney. And he's always the person to nerd out with over, really the most complicated types of scenarios. And I definitely picked his brain a lot about, leading up to all of this. And I really thought it'd be very helpful, Greg, to have Andrew on the call because he's already had some of these experiences in the removal defense context, right? Related to students, especially when we're talking about like the first wave related to protest aspects. So
yeah,
I thought it would help to round out the conversation a lot as well.
Andrew is going to be really helpful when we talk about what happens if we can't fix the student issues, and right. what are some other options for people who are just not ready to depart without trying something else. Adam, first of all, what are we talking about here? We're talking about these. Initially, if we had this conversation 2 weeks ago, we would have been talking about visa revocations at the consulates, but we're talking about now SEVIS. So can you explain to, obviously the students that are watching understand this, but there are others as well that are watching that sort of vaguely know something's going on from the news, but don't really understand exactly what has been happening.
Yeah, absolutely. And I mean, I think the best way to explain it, Greg, is to kind of put it in terms of like the history of how these things would typically unfold, right? If there was some type of conduct or arrest or some type of action that led to a visa revocation, that would simply mean that that individual would be not able to enter the next time they traveled unless, they obtained a new visa to be able to re-enter. That could go for F1 status, that could go for a variety of other statuses, right? That a visa is simply a ticket to present yourself for entry to the U.S. It is not a status in and of itself. And usually if there was something, I mean, I'm sure, Andrew, you can back me up on this, but there were different prudential visa revocations for DUI issues. That's been known, that's been common, but it usually would stop there. And the person would just need to handle it the next time they traveled and apply for a new visa. It was always possible, though unlikely, for it to go beyond that, where a person could be placed into removal proceedings for having that revocation, and I think it's part of the being present in violation of the law type of category.
By the way, do you get notified when your visa is revoked, or do you just find out when you try and come in using it?
They're supposed to contact the the email address that you used on the DS-160. Okay. And in this current environment, it is readily happening. I am seeing it. I think it's difficult if an email address changes, right? Like you had a particular, maybe a student email address for the DS-160, and you don't have access to that anymore, if you're not currently enrolled in the school, it may be difficult to get that.
Right.
What is happening, the element that is so different here is what is happening with the student's SEVIS record. So we were always probably heading toward having this monitoring system even before 9/11. But there was this renewed urgency for there to be this monitoring process after 9/11, because I think one of the people was, one of the hijackers was, at an aviation school, I think. And it led to them making F, M, and J categories among the most monitored in the planet. Any type of action, any move that the student makes is somehow recorded in SEVIS, whether it's transfers, reduced course load, applying for OPT, STEM OPT. These are all monitored in that system. That is the system by which that student moves about. And there are universities that have accreditations that are able to and are charged with, updating the SEVIS record every time those actions happen for that particular student. So what the government is doing essentially is they are terminating this record. First, it was related to protests, and it was the Combating Anti-Semitism memo, and so it had to do with protests and Middle East politics. And that was the first wave. And the greater, much more substantial wave, I think now up to maybe 4,800 students is what I heard last, is caught in this dragnet where they have had any type of encounter with law enforcement. Could be dismissed charges, and in many cases they are dismissed charges, and they're leading to this termination, which then, I think it is, obviously it's a question for the federal courts, but it tends to render that student out of status, at least in practice, and also by government policy.
Okay. So we have these revocations happening, and 4,800, I guess, is the last number we're working with, although nobody really knows what the number is because the government's not telling anybody what the actual number is. So once this revocation happens, that's also, are they getting what information can they find out about why it happened? First of all, why? You mentioned that any encounter with law enforcement. And you and I were talking before the call about the fact that there are also reports from people that are monitoring case by case, that there also are people who have no idea why it's happened, that they have no political activity and they have no encounters that they're, that at least that they would indicate that with law enforcement. So there may be some people in that category. And actually, I'm really interested in hearing from those folks, that are in that category, because I would like to verify for myself that that's happening. But when we have so how does one figure out what the government is claiming as the reason?
Yeah, there's really not much information that's provided, right? So first off, the students, if they're getting anything, all it is this visa revocation email that is, worded in a pretty scary way, but it doesn't really provide much detail in terms of what is the reason for the revocation. Now, the universities, they've been running, lists related to these terminations, right? So that they can provide, as they should, notification to students about the termination record, just as they would in any other circumstance where there was a SEVIS termination. And, what they're seeing are reasons like otherwise failing to maintain status, or I think they're using other as a termination reason itself. And it will say identified in criminal records, something to that extent. But it will mention the word criminal that leads them to understand, okay, there's something here. Now, let me try to remember, what could that possibly be? Oh, I did have that speeding ticket once upon a time, or, oh, there was this charge I had, but it was dismissed a long time ago. And so that's really mostly what we're seeing. It was in the first wave, it was especially, it would mention that there were adverse foreign policy reasons, and it would mention the particular section of the INA. I think in this latest round, it's not even providing the same level of detail in terms of any type of ground of removal. It's just simply saying, other or otherwise failing to maintain status and saying that they're identified in a criminal record. But they're really left, Greg, to like try to figure out themselves what was the basis of this, what is the underlying issue.
So what's happening once this happens as far as their enrollment in school or their OPT, or like what is the immediate effect when this action happens?
Yeah, and I think that, when it comes to enrollment, I think that that's oftentimes a university by university policy or even a state policy, where in some states you can't be enrolled, like they have to check for unlawful presence. And they have to report for it, and the student's not able to be enrolled if they're considered to be, not present with any type of status. So that's not so much an immigration issue, right? Because we know in some states, you could be undocumented or you could have DACA and you could still attend school. So that's more of an institutional or state policy than it is federal immigration. In terms of the working aspect, I think it depends on what the current position of the government is in terms of responses to litigation somewhat differs from the reality that we see with policy as it's been expressed for years by government agencies, by SEVP, that if your record is terminated, you have no ability to work. You lose your work authorization.
So we're gonna talk a little bit more deeply about litigation, but you're mentioning something that is going to be important when we talk about the litigation, which is universities and students are instructed that they are automatically out of status based on the information that's on SEVIS. But as we'll mention when we get into litigation, just in the last 24 hours, a declaration was filed by ICE saying that in fact a person is not out of status because of the revocation, and we'll talk about sort of like why actually I think I'm going to read maybe even present the language from that declaration, because it was really weaselly, I think, as far as the way the government presented it. But we have this so we have this question about whether the student is in status, whether they can enroll, and the schools are sort of left in a confusing spot as far as what they can do. The students themselves, obviously it's kind of, after you get through being completely stunned by this news, there are some things that we can talk about, certain strategies that might be available, and also certain things that steps that students should take immediately if they think they might be in this category of people who could potentially see a revocation, particularly anybody who's had any moving violations with cars or anything that like where they've had any encounter with a police officer. By the way, I think why, we were also trying to say, when we were explaining why some people might be hearing, even though they don't have any encounters on there, is they don't have an exact matching system set up. So if a police officer, puts if they have a fingerprint, they might be able to go through a match. But I'm not so sure that ICE is doing fingerprint matching to make sure that these records match the students that are being contacted. And I do think it's very possible that if you had, two people with the same name in the same town, and there's a police record for them, that they are not giving the benefit of a doubt to the student and are just pulling their record out of SEVIS, even if they have found, even if it's not the same person on there. I don't know that for a fact that that's true, but I can see it being true based on the speed and the sloppiness that that we've seen in other spaces, like immigration lawyers getting emails saying that you have 7 days to leave the country. We know that they are not doing a lot of vetting and double checking on any of the stuff that they're doing right now. So that's
something, with respect to how quickly these rolled out with. I mean, we're talking about close to 5,000 from what we know, right, that were caught in this dragnet. And it's happened in a period of like what, 2 weeks at most?
Well, and it seems like it's only picking up pace based on
Yeah.
we've heard reports this afternoon of like bigger numbers.
Yeah.
That and so I can't imagine that that number is not going to rise fairly.
Feels like it's happening in a fairly automated fashion, right? And it's kind of just left for everyone to sort it out.
Yeah. All right. So
litigation, et cetera.
Let's get into options. So let's go for we'll go in order of sort of the most conventional options to the ones that are maybe more aggressive.
Yeah. Yeah. Okay. So, I think when it comes to the conventional aspects, I mean, there's certainly been a lot of conversations about reinstatements.
Mm-hmm.
And I think that, even really among immigration attorneys, there's some level of sort of division of thought in terms of
what's a reinstatement?
So a reinstatement is basically, it's a process that's filed with USCIS as a way to basically return that person back to their F1 status. Mm-hmm. And, once it's filed, they're supposed to be allowed to, continue with their studies. And, they're supposed to file it within 5 months of the termination, or there's a higher threshold that they have to meet when it's outside the 5 months. So that's kind of the basics of it. But, the reason why it's somewhat difficult, right, is, first off, one of the parts of the regulations talk about that you need to be pursuing a course of study or intending to pursue a course of study. And a large percentage of the students I've talked to are currently on OPT or STEM OPT, and they're not planning to return for their education. So that's, part of the difficulty of it. They also tend to take a while. There's no way to premium process them. A lot of us who have done advocacy around international education and have talked to, government agencies and USCIS have tried to advocate for some premium processing because it does create a big burden on students to have them take so long. But, I've seen them take several months to be adjudicated, which is not ideal in this particular situation. And it also, as I'm sure Andrew can attest, it also does not prevent someone from being detained or from being put into removal proceedings, right? So, and it's not necessary in the sense that, the SEVIS termination is a final agency action. So if you're looking at it for purposes of litigation, it's not essential to do it. Now, there could be reasons potentially, like if the person qualifies, they are in school, right? There's, to my mind's eye, they're eligible if they've been otherwise maintaining their status. Whatever's happening to them are for reasons beyond their control. They are, not deportable, right? And there's like different grounds of removability that it addresses, like failing to maintain status or being present in violation of the law, which if you have a reason apart from that for being removable, you can apply for a reinstatement. But I mean, in most cases, they're not removable on any ground. So
what would happen after reinstatement? Does the SEVIS record automatically get how does it, is it like turn back on, or somebody has to create a record?
I'm trying to think of the exact mechanism. I mean, it gets approved and it makes by some way or another, it makes the record active again, essentially. Okay. So there is a data feed between the USCIS claims system and SEVIS. So it may be that it's an automatic data feed of the approval to make the record active again, or it's something that sometimes DSOs have to do a data fix because there's sometimes glitch issues where the connection doesn't feed automatically as it should.
Right.
Yeah.
Okay. All right.
So that's
reinstatement.
Possibly. Yeah.
Reinstatement definitely means somebody's going to probably miss at least a semester, and they are at risk at any time of being picked up, potentially detained, and potentially put into removal proceedings.
Yeah, I mean, they may be able. I think one benefit of the reinstatement is that you are able to continue attending school, which may be in a situation where state or institutional policy makes you not able to enroll if you are out of status, then maybe the reinstatement helps in that regard. But I think, I mean, I don't think it's a perfect solution.
What about their work authorization? If they are, when you're seeking reinstatement, can you still work on your work card, or because that's that revocation would have to happen by USCIS.
Yeah, I mean, I think that's kind of that's the issue, right? And I mean, again, in a lot of these situations, I mean, the regulations say that you're pursuing education or intending to pursue education. Okay. So I don't know how that works in conjunction with a post-completion OPT or STEM OPT. I think it's arguable. Maybe like a CPT, if you're on CPT, curricular practical training, maybe you can continue that because that's integral to the course of study. So, continuing your enrollment via that filed reinstatement, I would imagine you could still engage in the CPT, but I'm not as certain about the OPT and the STEM OPT.
Okay,
that's the difficulty.
All right, and so we also I know that some people have inquired about whether a school can, if they think it was just a complete mistake, could just try and set up a new record. And you were pretty skeptical that would be successful.
Well, I had heard it reported, and I imagine there are some DSOs who are tuning in as well. Thank you for joining, and they can add their wisdom, if they feel comfortable. But I believe that the data fixes really haven't been working. The data fixes that have been attempted.
Right, and we actually had a DSO who chimed in on the question about working after the reinstatement was filed, and who's, and I have no reason to believe this is not correct, said that they can continue enrollment in school, but they can't work. Now, I don't know if that's work on. I mean, and Angie, you posted that, if that's work on campus or optional practical training or CPT. Anyway,
probably the OPT aspect, I would say.
Right. Okay. So we have we have those two options. One is a very unlikely one, and one is the reinstatement might be more likely, but is time consuming, and a lot of people might not qualify on there. Although it might be, if somebody can continue enrollment and all they're trying to do is finish out the school year because they have they're about to finish, that might be the best option if this for them if they're in that situation. If they need to be, if we're talking about a longer period of time, I think that really, at this point, until we've heard more from the government where they set up some kind of procedure where we can, the redress procedure where people can, find out if, especially for people where we think there's a complete error on there, that we haven't heard anything yet. If anybody's watching that has heard anything more than we have as far as the government's providing some kind of way to reach out to them to fix a problem, like an erroneous, well, they're probably mostly erroneous revocations, but we haven't heard that yet. So that brings us to litigation.
I will say also, Greg, that some folks have weighed in that the data fixes have not been working.
Okay.
So that echoes what I've been hearing as well.
There's actually one more thing, fellas, that I think what I've seen in consultations, I've been noticing a lot of inconsistencies with E-Verify as far as the validity of work permits, because I've had a lot of these consultations where they're on OPT or STEM OPT, and they've been approached this very inconsistent, very arbitrary. I have not been able to discern any pattern where they're notified by their employer that they got a notification from E-Verify saying there's a document mismatch. And when they reverse engineer what the document is, it's the EAD, but it's not happening everywhere. So I think that's important for the people to note. For whatever it's worth, my view is, if the government wants to revoke before expiration, there has to be a notice as provided by regulation in 8 CFR 274. but I don't know why the government is doing it in some places, but not others. I've asked them what their fields are, what their jobs are. And it's not like everybody that's being revoked is working for, on chemical research. They're just completely across the studies.
So the E-Verify is showing that the card is revoked?
That the phrase that I've heard, Greg, is document mismatch. And then when they go in, it says that the validity has been canceled or revoked prior to its expiration.
Have they checked also at uscis.gov by plugging in the receipt number for the EAD and seeing if there's a notice that's posted there also, or you haven't heard that?
I haven't heard that, but I always, in my list of questions now for these consults, that's what I'm asking. And I put together just some numbers. 9 people have reported E-Verify mismatches. 11 people have heard no such thing. So I've had 20 consults with OPT, STEM OPT. And I asked this question, and it's almost split down the middle. And there's not even a similarity of jobs that, you could say, well, maybe it's because they work with, chemicals or whatever. No, it's one guy was working.
Yeah, I mean, it sounds to me like it might be something that's happening manually, and they're just getting to them at a, wherever they are in line is probably what the answer is. That's interesting. And ICE runs E-Verify, and ICE runs SEVIS, and USCIS runs the 765s and reinstatement. And I mean, there also is, it's potentially, I'm curious about sort of what are the interagency communications. And it would be interesting on these E-Verify ones, Andrew, if they're showing that document mismatch there, but are still not showing on the on USCIS.gov, or maybe they're waiting on USCIS.gov to do their change, and then they will make the change there. So it might be interesting to find out from the people that also are not, if something happens on the USCIS side that then triggers the change in E-Verify. In any case, let's change over to talking about litigation, because I know that that's for a lot of people what they wanted to probably hear about the most on this call. And we have, so let me just preface by telling folks that we have so our law firm for several years has been part of a group of law firms, the 4 firms that make up Impact Litigation, and we have been working on federal litigation together with our partner firms in Denver, Atlanta, and Boston, and we have been having discussions with the firms that have already started working on some of these cases. But there's 2 steps in these cases. There's the initial step where we're asking a judge to take a immediate action, and somebody had posted in the questions about TROs. That's a temporary restraining order. That is one type of action. There's also a preliminary injunction is another one. The TROs have a higher standard, but they are tend to be faster as far as getting a decision. And there have been reported about 100 cases around the country that have been filed in the last couple of days for students in the courts. And we've, Adam, I know you and I have started looking at some of the filings for some of the other cases and some of the decisions that have come in from judges already. And there have been some successes, and some students have gotten TROs with the order by the of the government to reinstate them in SEVIS, and they can later potentially could be revoked again if they win later on. But for now, the judges are saying they have to make those changes, and it seems like the initial ones were very rapid success. There has been a couple of bumps now on some of the, at least on one TRO that was denied, and another one that was turned over after ICE provided a declaration. But Adam, maybe you can talk a little bit about sort of what the claims have been. I mean, I know we're talking about APA and due process and et cetera, but and maybe explain why it's a little bit different to be suing on SEVIS revocations than visa revocations.
Yeah, and I mean, I think that, and you might have some added thoughts on it, but I when it comes to the visa revocations, my understanding is there's really not as much that can be done in that respect. There's a lot more discretion. I'm not super well versed on the particular aspects of
I think suing on visa revocations is probably a loser.
But
for now, unless it was a class action where you can show, but I think for individuals suing on this issue, they're going to have a problem.
But I think that, what I've been seeing in terms of the litigation is just based on a violation of the Administrative Procedures Act because of, arbitrary and capricious action, basically, to essentially unilaterally terminate the individual's student status, right? Terminate their record without any type of opportunity afforded for a due process hearing of some sort, right? Because these are not individuals like this latest round. These are not individuals that have been placed into removal proceedings, right? Which, could happen and does afford that opportunity for, basically a judicial review, right, of the actions that were taken. In this case, though, this unilateral action that renders a student out of status, it's done without any way to challenge it, right? Even if the filing of a reinstatement wouldn't be challenging essentially the underlying action, right? It would be restoring the person to status, but it's a different framework, right? It has different eligibility criteria. Right. So it's taking away that it's basically, that's why it's a violation of the Administrative Procedures Act. And it's also, claimed on the basis of, same idea of due process rights under the Fifth Amendment as well. So we've also been seeing in terms of, when it comes to the first wave related to protests is, First Amendment challenges, essentially, right? Freedom of speech.
Right. All right. So, as far as the, I think one of the more interesting defenses that we've seen from ICE came in the case that we were just talking about beforehand. This was there were 4 Chinese nationals, and this was in the Eastern District of Michigan. And in this case, the ICE was successful, I believe, on stopping the. I don't know if this was the one that where the TRO was denied based on this, but
I've seen this stated, though, like what you're about to say, in a few different matters. So I think it is a position they tend to be taking now. Yeah.
Yeah, I was going to try and do a screen share. Let me see if I can, but I don't think I can. Maybe you can. But in this case, the paragraph that's the most important. I'll just read it out. This is a declaration from a senior officer at ICE. That is in charge of SEVIS, that said terminating a record in SEVIS does not terminate an individual's non-immigrant status in the United States. The statute and regulations do not provide SEVP, that's the agency that runs SEVIS, the authority to terminate non-immigrant status by terminating a SEVIS record, and SEVP has never claimed that it had terminated the non-immigrant status of the 4 individuals. Furthermore, the authority to issue or revoke visas for non-immigrant status lies with the Department of State, not SEVP. Terminating a record within SEVIS does not affect a visa revocation. Now, this is one where I said this is like it's going to get a judge mad when it's explained to him how they've basically fooled the judge into thinking by sort of switching subjects in the middle of his paragraph. Terminating a record in SEVIS. So this is, first of all, this is contrary to what is actually on the SEVIS website. As far as on that website, it says that if your status is revoked by ICE, you are out of status. It says that on the site. So if that's
right, you're not in a period of stay, right? Of authorized stay. Exactly.
right. So that's the first contradiction. The second one is what they don't say in this paragraph, which is status is actually, so they say it's automatic on their website, but even if this was correct, it's misleading the judge because the SEVIS, yes, this should be the way it works because ICE does not revoke status. ICE is not controlling your status. USCIS is controlling your status. And CBP issues the I-94, but while you're in the United States, it would be USCIS that would revoke your status in most cases. And they don't say in here that USCIS is not going to revoke the status as a result of the termination of the SEVIS record. And we would fully expect probably at some point for USCIS to issue a notice saying that your status is revoked and you need to leave the country, or more likely they're just going to put the person into removal proceedings based on USCIS's determination that they're not in status. So they're not saying that. As far as the visa, the question wasn't even about the visa revocation. That's why I thought it was a little ridiculous for them to say
the concept inflated. Yeah,
like a little switcheroo on here where they're saying this is not a visa revocation. It's like, no, I think the lawyers who sued you understood that this was not about a visa revocation. This is about a person being put out of status.
Can I also add, since we have a lot of students and we have a lot of DSOs, on this live stream, that they know and walk about this system basically daily, right? So they know the logistical, like it's all well and good and you can say somebody's in status, but how are they going to transfer there to another school? What if they get sick and they need a reduced course load? What if they want to apply for OPT? What if they want to report their unemployment time, their employment time, so that they're not hitting that unemployment counter for their OPT time? What if they want to apply for STEM OPT, right? What if they want to change status to another status? There's so many aspects to this, logistically, mechanistically, that it's problematic, basically to say that they're in this lawful status, because the lawful status, right, when they come in with an I-94, but the I-94 is duration of status, which is governed by their course of study, which is all explained within SEVIS. So, that is the pronouncement of their status. So I don't know exactly what the path is forward for someone who has a terminated record, but is deemed by this particular.
And what would happen if they travel? Let's just say they're right, that SEVIS doesn't effectuate a visa revocation, and their student visa is still valid, and they have some emergency. They have to, and maybe they're still enrolled because of what we talked about before. But there's no longer a SEVIS record for them. Now they have to travel in the case of an emergency. They still have a valid visa, apparently, based on what they're saying in this paragraph. What is the likelihood that CBP is going to admit them when there's no SEVIS record for the person?
Well, that's what I'm not certain about either. I think that it's, is this information going to be shared around? Is this one declaration, by ICE? Is this something that is commonly understood by all of the government agencies? I think that there's some real concerns about what.
Well, they're not even consistent within their own agency. Right. My guess is that if you go right now onto the SEVIS. By the way, go on the SEVIS website and screenshot that before they try and take it away on there. But that would be, so they're not even consistent within their own agency, much less to the three other agencies that we're talking about, which is USCIS, CBP, and Department of State, that all have a role in this process.
I want to say I just got in a comment from one of our DSO colleagues that reminded me about the fact that you have to do you have to get a new I-20 with it's like a travel validation, right? Anytime that you travel, but
Right.
if the record's terminated,
Right. So no travel for
so,
you. All right. So it's yeah. So this is really snookering the judge to making it sound like, why are they suing? Everything is normal. I don't know why, on there, as if the SEVIS doesn't actually have any like consequences on, so, all right. So, back on litigation strategies, like I said, we are aware of a handful of cases right now. And I think Bloomberg, Andrew Craigbaum, posted about or wrote about it today. Said that he's the one that had already identified 100 lawsuits. There have been a couple that he gave us examples of TROs that have been issued. I haven't heard about. Well, we've heard about this case, and we've heard about one in Washington, I think, where where there was a reversal of course, I believe, on the part of the judge. So I think there are two cases that we're aware of that the TROs had problems, but there were at least several other cases that have worked. And I think when the lawyers go back to the judges in these cases, they are probably going to have some effective arguments, even along the lines of what we just talked about. But I don't really know that there are any good choices. Reinstatement is one that can be tried, but if you want something done relatively quickly, you really don't have a choice but to litigate at this point.
I'll mention just a couple other things that I think could be, that I think are important. And then I have a question for you too, Andrew. So, one of them, changes of status to, spouses, like a derivative status, F2, H4. If you have somebody who's on OPT, STEM OPT, maybe they were counted in the lottery, maybe they have a cap exempt H1B possibility. And so I think that it's interesting to consider some changes of status, maybe like a nunc-pro-tunc type of situation where it's essentially an exceptional circumstances where you're closing the gap because there have been no other types of violations.
If you use this paragraph from the declaration and say that they're still in status, then arguably they're eligible for a change of status still.
I mean, I think that that's a really good point too, because that's right. I mean, it's their own words, right? So I think in that case, maybe a nunc-pro-tunc in the alternative type of argument, but using their own words, it's workable, right?
Right. So you can look at changing, to another category if it's available. Yeah.
I would but I would ask Andrew, just in terms of other things, I don't know if you've been having some of these conversations about other types of like maybe even humanitarian statuses, right? That don't require the needle to be threaded between one status and another, like asylum. I mean, I know with TPS, that's already a difficult type of situation. Have you been having any of those conversations, Andrew?
Yes. I mean, always screening for U's, for asylum, and of course with.
Can you explain what a U visa is?
Yeah, U visa, it's U non-immigrant status, is for victims of qualifying criminal activity. There's a statute that lists the crimes in generic form. And if you're a victim of the state version of that general crime, you can approach the law enforcement agency that investigated. And if you cooperated with that agency and they have a policy. This is important to note that some law enforcement agencies have a "we don't sign them" policy. But if they're willing to sign a certification, then you can take that certification within 6 months and go to USCIS and file for your U1. You can include your spouse, U2. You can include your minor children, U3. And if you're really young, U1 petitioner under 21, you can include your parents, U4, and unmarried minor siblings, U5.
And could you study while you have that pending, or do you have to wait until there's some kind of determination?
Yeah, so that's going to go back to what Adam said with respect to the university's policy, because the receipt itself is not going to provide anything, and the receipt so states. But at least for now, if the only reason you can't be granted a U visa is the waiting period, they are giving out deferred action, and through that you can apply for a work permit that's valid for 4 years. I say for now because just today they seem to be reversing course in the special immigrant juvenile arena, where they're not giving deferred action for approved I-360s that are in the queue. So my mind immediately goes to, if they're doing it for SIJS, they're probably going to start doing it for U visas. So we may go back to the system that existed under Trump 1.0, where you file your U visa and you wait in the queue for 8 years before you get a work permit.
All right. Before you continue, I'm just, and Adam, need to check with you, but we would normally be ending at about the top of the hour, but we have a lot of questions and we still have a bunch of things to talk about. So I'm good to stay. Are you good to stay a little longer? Or Andrew, are you good to stay? All right. So we will stay and we're going to get through the questions. So don't worry that we're going to run out of time. All right. So Andrew, U visas were one. A lot of people are thinking about asylum. Tell us about who would be good candidates for that.
So the natural problem, Greg, with asylum cases is the 1-year filing deadline. Mm-hmm. Most of them are going to have that issue, if not all. And so federal statute requires that all asylum applicants file their application within 1 year after their last entry. Now, there is a specific regulation that provides for an exception for somebody who's maintaining status, but the caveat, and this is where a lot of cases can unravel, is the application has to be filed within a reasonable period of time of the claim arising. And so if the most recent example I had on Monday was an individual who was on STEM OPT and had a claim arise during the 2nd year of her studies, and she didn't pursue it. And I drained the well. There was no reason that she didn't file other than I didn't think I needed it because I was maintaining my F, and now apparently I'm not. So the problem there, this is the reason this all matters for the people, is in most situations, USCIS cannot entertain a withholding of removal application, which is the relief that you get if you don't qualify for asylum. Mm-hmm. So then you get an auto referral to the immigration court where you have to litigate all of this in removal proceedings. And that scares a lot of people from filing a 589 if they don't feel like they can overcome that 1-year issue.
Mm-hmm. Right. So one lesson from this might be that if you are not yet in the situation where your SEVIS record has been revoked, you might look at filing, if you think you have a good claim, filing before this actually happens. It doesn't help people, the 5,000 people or so that, or most of them that have already heard, but it might be something that might be preventative for others who have a good claim.
Correct. And if you're maintaining status with the class of people you identified, Greg, those cases are not referred to removal proceedings. You get an asylum final denial. So at least you can kind of make the argument that you get a free-ish crack at the apple if you've had no encounters with law enforcement. Of course, we can always have the arbitrary issues that we've been talking about, but if you've had no speeding tickets, parking violations, and you have a reasonable argument that you're filing your claim timely and you litigate it, you file it administratively, you go to your interview, you don't win, maybe you end up in removal proceedings down the line. But if you're maintaining your F, they're not gonna issue an NTA.
Okay. All right. So Adam, let's start getting into questions. And I know
let me say just a couple things just before we do that. So one other thing that I wanted to mention was that we've been having some conversations with people who, fell in love in university and, have possibilities of like a marriage-based green card process, especially if it's marriage to a U.S. citizen, more complicated if it's marriage to a green card holder, right? Just in terms of the status, it's not treated the same way. Like marriage to a U.S. citizen is, you need a legal entry in these particular cases, right? We're talking about, that's how it usually shakes out because they've come in the F1 status. So that's more workable. The other thing that I just want to say, just kind of as a general message to you all, there are a lot of eyes on this right now, in terms of what's happening. So like message to our students, there are a lot of immigration lawyers who are looking into these issues, who are speaking about these issues, who are writing about these issues, who are thinking about these issues. There are litigators, there are attorneys like Andrew who are helping students in immigration court proceedings. And there's organizations, all of your DSOs, international education organizations like NAFSA, have really been just getting resources out to universities. And, there's just been that guidance and a lot of people thinking about these types of issues. So I just want to note that to you all. With that, I think we can turn to questions.
Yeah, and the way it works is if you are watching us on YouTube or Facebook or X or LinkedIn, you just ask a question and you would post a comment like you would to any post that was in there, and it will show up for us where we'll see it as a question, and then we can post that particular question. Adam, I changed your link. Adam set up a separate link for students because we are trying to expedite the process of getting them appointments, since this is so, these are all emergencies on there. So Adam, I changed that very long link that you had to a bit.ly link that was a lot shorter. People aren't screenshotting here.
I would also add that I think that's a link for me. And I would just note that we have 2 other attorneys in our office who are also doing consultations for this. So just be aware there are other possibilities if,
while you're answering questions, I'll post our phone number. Andrew, do you want your phone number on here? If you could just pass me a text and I'll put yours on here as well.
Sure.
Okay. So I'm going to stick to questions. We had some questions on other subjects, but we promised people tonight was all about students. So let's just go with the questions that people are asking. And the first one is from Asia about, so we talked about in some of these cases where there were dismissed charges. I think what you would want, first of all, if you had a lawyer who helped you with the process initially, this would be a good time to go get your file from that lawyer and have at least a copy of the file from that lawyer that you can present to the immigration lawyers so that they know what they're working with as far as what your situation was. But that would be, and you can also, especially traffic records and things like that, I would go, if you fall in that situation where you've had any encounters with law enforcement, even really ones you thought were minor and not worth reporting, you should go ahead and get the copies of your records and make sure you have them available. Now, you probably do have them available, but already. But if you don't, go ahead and get them so that you don't have to, after a consultation, go and try and track it down for the lawyer. The lawyer is going to want to see it when you're having that initial interview. But that would typically, like I said, it would either be from the court that was responsible for the action. You can usually just go to the court and they would give you a copy of any record that was about you, or you can ask your lawyer about it as well. I don't know, Andrew, do you have anything further than that?
Yeah, I've actually been testing out an idea. There's all this talk about expungements and whether they count, but I think you can use expungements to your favor for the students out there listening to this live stream, because if all of your charges are dismissed, so basically what I'm doing is taking Greg's sage wisdom and just adding a point onto it. After you get those records, you keep them safe, you get them certified, and if you move for an expungement, which in most cases you're going to get it, it's going to make it very difficult for the federal government to find it. And there's no reason.
Why would that work here, and when it wouldn't normally work in like removal proceedings, where an expungement wouldn't save the day?
Yeah. So we're and this is a great nuanced point: dismissal versus conviction. So if it's, and now this is something that a lawyer needs to determine. So if it's determined that it was a true dismissal, and we say true dismissal because a lot of things that say dismissal for state purposes aren't dismissals for federal purposes, but to keep the conversation moving, we're going to assume these are true dismissals. It's not arguable. Then there's nothing to worry about in a removal proceeding because it was completely dismissed, and you have the records before the expungement. If you get the records before the expungement, then it doesn't matter if the records are later erased because you have copies that you did before the expungement. So I'm telling people who are just calling in a frantic they haven't gotten any SEVIS or visa revocation emails, talk to a criminal guy. See if you can get it expunged. Once you get all the records certified, keep them safe. And then it's going to be really difficult for the feds to find expunged charges, given that expungements are supposed to erase everything. So,
okay. That's there's no, and it doesn't seem like there's any downside to doing that. And it might be a good upside. Mm-hmm. All right. I'm going to switch to this. I think is an interesting question about somebody who is in the situation and then they left the country. What can they do? So first off, if this is not a visa revocation, person could come back in the country, if maybe, but they could come back in the country. Certainly, I think do they need to be physically present to litigate? I don't think so. I think this could be pursued if they're out of the country. The question about not the question of the visa side of things, but the question about the SEVIS termination, and if they get the TRO and they get the SEVIS record reinstated, then presumably they would be able to come back in.
I think it also depends on whether, if they have that SEVIS termination.
But I'm saying if litigation is successful, and then the question is, can they litigate without physically being present? And I think they can. That's especially if you can show the only reason they can't get back into the country is because of the basis for the suit.
I think it also depends on what it's doing for them at that point. If they're outside the U.S., like, do they need that record to then be active, right? Because if an I-20 is issued, now I have heard some things about students, maybe not being able to get a new I-20, but I haven't seen, maybe some of our DSO colleagues can comment on that. But if they are getting an I-20 for a new course of study at that point, I don't know whether the litigation would be necessary in that situation, but they are sort of at the mercy then of the consular officer when they go and they apply for that F1 visa, or maybe some other subsequent visa, like maybe they do have an H-1B option or something of that sort, which probably even be better than applying for the F1. It's hard to know really how these F1 visas are going to be adjudicated for those who've left. There's certainly they should try. Certainly students should try to acquire an F1 visa to.
Well, but this person already has an F1 visa.
Well, but it's been revoked, right? I think the visa was revoked in that situation because usually they're doing it.
This says both have been revoked. So I was thinking I was thinking it was just the one had been revoked, but they still had a valid F1 visa. So they still, presume, and actually that's interesting if they happened in tandem, because I'd actually like to hear from the HIs on that, because that seems to be contrary to what the ICE said in their declaration, that they are doing both at the same time, that there's any coordination or anything that's happening.
Yeah, I mean, they're revoking. I mean, it's very commonplace for there to be a revocation of the visa and a termination of the SEVIS record.
Right. But what I will state the last sentence of paragraph 22 of the declaration: terminating a record within SEVIS does not effectuate a visa revocation. Mm-hmm. So they are telling judges that this is not, one doesn't have anything to do with the other. If that is in fact not the case, we need evidence of that to present to judges when we inevitably get declarations from ICE making these claims. So that would be interesting, to see on that. As far as the visa denial itself, that's going to be the challenge, I think, and that's also why somebody should not, one reason not to leave the country, if you're going through this process. That if the visa revocation happens, you're going to have a hard time getting that, a much harder time getting that reversed. Then
you lose those due process rights, don't you? When you're
but there's also case law that makes it very difficult to litigate denials of visas. So it's different when you're in the country. You have different rights. All right, so let's keep going. So thank you, Angie, for that comment. That was helpful. And same as well for Stephanie. Thank you. And let's see. I attempted 2 with court paperwork showing the dismissal of the court case. Okay. Well, that's not encouraging.
But it would be interesting if DSOs do this after an expungement might occur. If that happens, I would be really interesting to see if that would change anything.
It would also be DSOs that are on this tonight as well. Would be interesting for the lawyers working on these cases is to potentially make yourselves available to do declarations showing that things that the government is claiming are options for students are not actually working. So we might want to reach out to some of you if you would be interested in participating in a project like that. I'm not talking about your own school and your own students, but potentially just as an expert, because you guys are actually working in these systems and you're seeing in reality what's happening. Okay, and Lisa was just mentioning the reinstatement applications, so we had talked about that. So we talked about TROs and that a lot of attorneys are taking that path. Can TROs help in reactivating the SEVIS record if the TRO is approved? The answer is yes, and I believe in it. And it's been the TROs I've heard are sort of like different flavors. Some of them are actually ordering the reinstatement of the SEVIS application. Some of them seem to be operating on the assumption that the person is out of status, and the TROs are about the person being able to remain in the United States and not removable. So that's also important, because if we think that people are going to get notices to appear in immigration court, that would be
yeah, to that end, actually, Andrew, did you want to maybe talk about just briefly the removal proceeding aspect there, and if a judge, if students put into removal proceedings and a judge dismisses those proceedings, what happens with the SEVIS record, like what you've seen?
Yeah. Have you gotten to that yet?
Oh,
I'm asking Andrew's actually gotten to that point in any of these cases yet.
It was the one that I told you about, Adam.
Mm-hmm.
When we initially,
yeah, but I know it, but not everyone else.
It was one of the earliest ones where ICE was sloppy, and they only charged 237A1B, present in violation of law. Now, this is very important why it's sloppy, because if they only charge 237A1B, you can, under statute, get judicial review of the visa revocation if they do that. So in one of the earliest cases, I guess whoever was drawing up the NTA was not in consultation with legal counsel, and they just charged A1B. And we went to he was picked up for after the SEVIS was terminated. They just went to his house and picked him up, took him to Louisiana, and then it was just motions practice. But the point is that, of course, we denied the allegation, denied the charge, and then the judge set a scheduling order down requiring the government to submit proof. They submitted very, very sloppy declarations like Greg read to us, very inconsistent language. The arguments were wide-ranging from sensitive gang databases to CI affidavits to state secrets, but none of them were corroborated. This judge was having none of it. And I figured this question would be asked. And so I went back to my notes and wrote down what she said. Mr. Rankin, please tell me what this order needs to say. Just sit with that for a minute. So I told her, I want the box checked on the form order that says your status under 101A15F Romanet 1 is approved. And I had her put in parenthesis, reinstated, close parenthesis. And then in the other, it said DHS will take all necessary and appropriate steps to reactivate the student's SEVIS record. They reserved appeal, but they never filed it. Final order, case closed.
Nice. All right, let's keep going on questions. So this is someone was asking about the risk of reinstatement. If it's rejected, what are the consequences if a reinstatement is rejected? Is it too late at that point to pursue any of the other options like change of status or anything like that? I mean, I think it's harder to do change of status because you're going to have to base it on, you're going to have to do a late filing. You might be able to file for a visa at a consulate, leave and re-enter. You're not going to be subject, Adam, I guess, to the 3 and 10 year bars.
Well, but I think the issue with that,
unless there's a finding that you're out of status.
If you have, so if you get a reinstatement denial, right? There's a couple things, right? So if you get a reinstatement denial, that is essentially USCIS is probably determining that you are accruing a lawful presence, which, it's not the same thing as status for all of you, right? Accrual of unlawful presence means that you are accruing up to 180 days. You could have a 3-year bar to return, and it goes on from there. So that is a risk of submitting a reinstatement. Is in the case of denial, there might be that starting to accrue unlawful presence,
right?
Which
the really
very likely not occurring right now with a SEVIS termination. And I could nerd into those reasons, but
we got a ton of questions, so let's
move on.
Keep it going. All right, so this is a question about whether H-1Bs have been coming up.
No.
Generally, no, although I did hear from somebody this week who presented himself at a port of entry and the ended up being denied and having the cancellation of the visa, et cetera, on there because the CBP believed that his employer was was requiring him to pay some of the filing fees and the legal fees, which he said he never said any of that in there, and he had to sign something to that effect. But that's not something that would be particularly normal that we'd seen in the past, where there would be that kind of scrutiny by CBP officers, except in the first Trump administration, where there were weird H-1Bs questions that were asked, people losing their visas and then having to eventually get them back through other means. So that's, I think, generally a very exceptional case, but it is something that, and also there's sort of the Elon effect right now, which is that they have been told by Elon to lay off the H-1Bs for now on there. And as long as he has some sway in the administration, I don't think we're going to see anything really big happening in the H-1B space, but we'll see. Let's see. So this is a question about, Adam, I know you and I talked about this about whether you can pursue both simultaneously, and your answer was no.
Well, no, I actually, it's sort of a question in my mind. I'm actually leaning toward yes.
Okay.
Can I? So I think sort of part of the concern is whether it's, you know, if you do that, you're leaving the door open as, you know, maybe that the termination is not a final agency action because you have the reinstatement underway. But I don't think that that's. I'd be interested in other opinions on that, but I think that you can pursue both because I believe the SEVIS termination alone is final agency action. And if it's final agency action because the reinstatement is not
you need that to
litigating it, you know, the reinstatement isn't relitigating the termination, right? It can get somebody back into status maybe, but it's not. Final agency action has already occurred with the SEVIS termination. So therefore,
okay. I'm buying it.
You can litigate. You agree with yeah. So anyway, I think you can, because I think that they're addressing different things.
Okay. All right. So what do you make of the
and keep in mind for all the people who are listening to this answer that not in the student context, but in the removal context, the Supreme Court has put out a very great opinion in Santos Sicaria that talks about discretionary motions and whether those are required before you can get to federal litigation under the APA. I think there's a lot of analogy that can be drawn from that case to this. Is figuring out whether reinstatement is required to access the federal court. So I think there's a pretty good hook on precedent, not just using the APA statute, but also what the Supreme Court has said in recent years.
Okay. So this was somebody had asked a question about this. This is the actual language we were talking about before, and they were asking, what do we make of the following sentence? So we discussed that just to kind of reiterate on this, that one is that they are contradicting language on the SEVIS website. Two is that they don't actually say what USCIS will do with this information, which is pretty much guaranteed. I think at some point the USCIS will revoke a person's status if there's no SEVIS record for them anymore. So they're making it sound like the person's just fine. I don't think they are, and I don't think Adam thinks they are, and I don't think most people that are doing
Number three, it doesn't in any way reflect the reality of the need for all actions to go through the SEVIS system.
Yeah. So Frank Martinez had a question about successful TROs having clean records or alcohol violations. I haven't taken that deep a dive. We do know that some of them have had that they've had dismissals. So in that regard, I guess they're a clean record if they've had a dismissal. Just because you've been you could be arrested for murder, and if you were completely wrongfully accused and it's dismissed because they find somebody else actually did the murder, I would say you have a clean record just because you were at one point accused of something. The alcohol violations as well. I'm not sure that Adam. I guess this question is, what authority do they have to remove somebody? I mean, to revoke a record just for conduct, even if it's not illegal. Like, let's say, it's not something that it rises to the level of that. Maybe it's a DU. Well, I don't even know if it's we talk about a single DUI that is the most minimal of minimals. No injuries. No, nothing really serious, just sort of the most minor DUI that would potentially trigger, in the past that's triggered removals even for of the records and the visa revocations. But I don't think most of these cases there's any conviction for a DUI that's stuck on there. I think basically everything that we're hearing about are cases where people have been, because those cases probably there's a decent chance that those people already had, that they would have already have had problems before this before Trump even came in on there. So it's a good question, Frank. We have to, I'm not at this point. Somebody is keeping track of at least the revocations and what the issues have been for each one. Adam, I think we said that somebody had over 1,000 of these cases that they had tracked with information on what the of what they could tell were the reasons why they had happened. But I don't know.
I will also say, Greg, that there's, in non-immigrant regulations, just generally, there's just because you have some, one of these kinds of more minor type of issues and things of that sort, it doesn't result in somebody's losing non-immigrant status. I think in the criminal context, like if you're going to see it, it's probably like related to a crime of violence that is mentioned in the regulations, or working without employment authorization or things. I think there's something about a private bill with through Congress.
Yeah, that's not for that.
Anyway, yeah, exactly. So I mean, it's to answer your question, no, it's not just these types of incidents that automatically render somebody or allow DHS authority to terminate status.
I did see one in the removal space. The gentleman didn't hire me because of funding issues, but at the consult, this was I think what I call it, Greg, in my consults is vanilla DUI, which is never going to be a CIMT per longstanding BIA precedent.
That's a crime involving moral turpitude.
Crime involving moral turpitude. But what I did see, and I had never seen this charged before, I had to look it up. It was 237 A4A Romanet 2, which says any alien who has engaged, is engaged, or at any time after admission engages in any criminal activity which endangers public safety or national security. Somebody had the DUI, they did it under public safety, and then so when they terminated, this was one of the earlier waves, but in SEVIS, this actually was noted, exactly as you said, criminal database, whatever, and in the NTA, that was the statute that was charged, but I only saw it once.
Very interesting. That 237 there has a lot of squirrely little provisions in there that make grounds for removal. I'm not sure I understood this question.
Oh, no, this is part of a quote that he had from before. Yeah, you can move on.
Hi, Patricia.
Hi, Patricia.
Hey, Patricia. How's it going? Glad you're with us.
Patricia is an immigration lawyer in Jackson, Mississippi. And there are not too many immigration lawyers in Mississippi, so I'm glad she's available.
Thank you.
These are some of our DSO colleagues here.
Yeah. All right. So just don't know exactly where. Okay. Let's look for a question.
Yeah. There's one that's
all right. There's one on H4s. I'm not gonna do that. Save that for next week if you're back. And where are we? Oh, we still have a bunch. Okay.
Francis had one.
Here we go.
Hi, Francis.
If a CBP officer checks a student's record in SEVIS and it's terminated, they might not let them in. Most likely won't. Oh, so that was going back to that question we had before. What would happen?
Yes.
Okay. All right. So that's I think we all agree that that's the right answer. And then all right. So here's somebody in an interesting spot. So this person is in OPT. They've been picked in the H-1B lottery, and they have had their SEVIS terminated. Now, if they are still in status, there's a question about whether they can be working, but they would have the. Do you have to have a valid 7? I'm trying to remember on CAP-GAP, because CAP-GAP is based on valid F1 status, which arguably they're in valid F1 status. The 765 may or may not be valid at that point, but CAP-GAP might cover them on a different ground that would allow them to work until October.
Well, it's just an extension of that OPT EAD, right? So I think that's kind of the tricky part, right? Where, I mean, if currently the position of ICE is that they're still in a valid status, then yes, it's okay. But then other policy and even things on the SEVP website say that no, you lose when your record's terminated, you lose your employment authorization, right? This is why there's
I agree.
It's contradictory information right now.
Right. It is hard to advise here. It may be that, I mean, it might be that this might be a good candidate to litigate only because you might not be able to work for the next several months until October rolls around when the H-1B number becomes available. Good question. I wish we had a more precise answer on that. I knew, Adam, we were going to get that question on there about about people that were transitioning to H-1B status, and you can't file that change application.
Yeah. I think the issue is not so much the maintenance of status, but rather the continued work authorization. That's the problem, the cap gap.
Right. So we're not. We think the person can stay in status probably by filing the change, but they're not going to be authorized to work under cap gap in all likelihood if that 765 has been yanked. 765 hasn't been. All right. Let's say the 765 is there's no record of I guess that Andrew, can a person look themselves up and verify? I guess you can see there's two records. You can see USCIS.gov and see if there's any information about the revocation of the EAD happening, and the E-Verify would be, the employer. Well, I don't know if the employer is even allowed to check that. I don't know if that's even legal to do that. So that I guess you're going to have to rely on USCIS.gov on that particular question. And if USCIS.gov says your 765 is not been yanked yet, then I think you still get the benefit until it's gone on there. Now, if it is gone, I think that's a problem, and I think that you either are going to have to. You could depart and come back in on the H-1B later on, or you could stay in status but not be work authorized and then begin work on October 1st.
Look at your for all the students out there. I'm sure many of you have USCIS accounts. I presume a lot of these revocation notices, if they go out, are going to be uploaded, because that's what they've been doing for all the parolees that they're knocking out. Is if they have a USCIS account, they're just uploading a one-pager. Maybe you get an account number, a name. Some of them are just generic, but they put it on your account and they say that counts as the notice. So if you're waiting for the mail, that might never come. So for all of you students that have USCIS accounts, log in there. If a notice has been uploaded, you'll see a red exclamation mark that says action required, and you'll be able to click into the documents tab and then download the PDF.
All right. Juanita has an interesting question, and sorry I'm covering you up, Andrew, but
I'm the least important person here.
I think you might have something to say about this one, though. But
yeah.
All right. So Juanita has a student visa. Unfortunately, she had a misdemeanor. They canceled her visa and canceled SEVIS. She's on court supervision until January. She wants to leave the country since she can't study and she doesn't have a legal status anymore. Her question was, what happens if she leaves because she's still under court supervision? So I think you need to get your lawyer who is handling the action to, and I'll uncover Andrew.
Yeah.
I think you shouldn't just leave. That might be potentially violating the court's order of supervision. So I think the court would probably, my guess, given the circumstances with the revocation of your student status, would probably be agreeable to ending things and letting you leave. But I don't think leaving without working with the court to do that with the judge's blessing is a good idea. Disagreements?
None. That's the right idea.
Yeah.
Okay. So Jamila asked the question about the case. I am going to put the case is 4 very difficult to pronounce Chinese names versus Nome, but I'm going to give you the number of the Hold on a second. I'll do that as a banner in a second here, with this case number. That is the case number, and it is filed in the Eastern. It's filed in the Eastern District of Michigan, Southern Division. I'm putting the. I'll post in a. Well, that's about the best probably I'm going to be able to do right now, because I can't. I don't think I'm going to be able to paste all this stuff in. But that's the the official case number for the federal court system. On there, it is Chinmay Deore, Deore. Does it go by the last of the four names or the first? It's the first name, right? That is the first name in the versus Christy Nome, Todd Lyons, Robert Lynch. So I think this would just be Deore, Deore versus Nome, Noem, on there. But it is. Oh, you know what I can do? I can share the link. That's not going to work probably fairly well, but maybe somebody can post it in the in the questions. Anyway, that let's move on. But that's the name of it. If anybody really is wanting to read that, they can probably just contact me. I'm trying to find where we left off on the questions. That was Jamila.
Yeah, Montia had a question.
Oh, here we go. Okay, if you marry a U.S. citizen, do you have to leave the country, or am I at risk of being removed, detained during? Oh, so back to Adam had given that tip, and we kind of moved on a little too quickly as far as other options. Non-immigrant options, green card options, which would be probably the immediate relatives, would be the only options that would basically allow you to continue processing in the U.S. And spouse of a U.S. citizen is certainly one of those. So if a person is in the status of the revocation happening, they marry a U.S. citizen, they should be able to file an adjustment application. They're still 245A eligible, right, Andrew?
Correct.
So the interview should not result in removal or detention, because you can be out of status when you're filing based on a marriage to a U.S. citizen.
Right. But you've seen, but Andrew, they could possibly have to finalize it within removal proceedings, though, right?
They have apprehended people during interviews. It's not been super common, but it has happened in various contexts in the New Orleans area. I know of at least 4 in Memphis where it has happened.
Were those all right? So let's say that happens, and that's the risk. So, were any of those people detained or denied bonds?
No. What the trend now? I'm going to say it's an emerging trend, but one commonality I noted when I did these consultations is that all of them had their adjustment interviews, because, quick side note, the administration seems to be going back to a more global interview policy like they had under Trump 1.0. So right. You're likely to have an interview regardless, but let's continue with the analysis. All of these cases had their adjustment interviews set phenomenally fast. I'm talking less than 2 months.
Wow. Okay.
From filing to being called in.
So something was up.
Something was up. Something was rotten in Denmark. And all of them were picked up when they were set that fast. Now, bond was not difficult. These were low ball bonds. I got one 1,500, which is the lowest statutory that they can set. So they were quickly released, but then they were put into removal proceedings because of the termination. So they were charging A1C, 237 A1C, failing to maintain status, A1B, president violation of law. And then I would have to bifurcate the proceedings, go through the normal I-130 goes to USCIS, hold the proceedings, possibly administratively close, get a series of continuances, maybe put it on the status docket. And then once the I-130 is approved, come back and do the adjustment, because they're not terminating cases anymore. Prosecutorial discretion is a 4-letter word these days. So all of this can be made very expensive, very time consuming. It's not happening, to Montilla. This is not happening everywhere all the time, but plenty of experiences in New Orleans. I know of 4 in Memphis. I'm sure there are others.
Okay. So this was a question that was about how long well, actually, no, that's not. There was a question about TR. Oh, if you get the restraining order. Okay. So if you get the question was sort of how long does the TRO's protection last? Let's say the TRO or either guarantees that you're not going to have your F1 status revoked, or potentially even comes along with the SEVIS record being reinstated. I think it's important to understand that this is you haven't won, but you've really won on there because of the standards for what's in the TRO. So a TRO, you have to convince the court that you're going to suffer immediate and irreparable harm if the order is not issued, but you also have to show a strong likelihood of success on the merits of the underlying case and a clear need for protection. And it's that part, I think, that is the reason why most of the time the government's already been basically told by the judge you're going to lose. And they will in most cases, I think, they will drop the case on there, and they're not going to keep going because unless they can produce declarations or things like that, which they're trying to do on some of these early cases to send a message that to get people not to file these cases, which seem to be going pretty successfully on there. So I would say, my experience with federal litigation is it could be 6 to 10 months before the judge, you're going to be getting to the judge and actually arguing having a trial. That's what, these cases would end up is a trial, witnesses and everything else. And there's discovery and there's all kinds of things that can happen. And the government generally doesn't like any of those. So they will most likely, if they've lost on the TRO, really lost on the TRO, and they're not going to be getting that reversed, they are not going to be interested in sitting for depositions and providing all kinds of discovery that you're going to get if the case is actually going to go to trial. It's been my experience that trials are rare, and most of these cases are won or lost on the preliminary injunctions of the TROs.
I think sort of an added element to that too, Greg, is, for me, my removal defense knowledge is a little bit dusty, but I would ask our good colleague Andrew about this. So, in terms of detention, how does it, you can petition for like a bond hearing, right? You can't just be held indefinitely.
Well, you can ask for habeas. And actually,
right, there's habeas too. Yeah.
And I think actually AOA put an advisory out about habeas for detained students just this week on there. So
there's other elements to this, is what I want to tell our students, that there are other elements to this than just waiting on that restraining order.
Habeas is not just for alien enemies. You can use
there are other tools. Yeah.
All right. So Patricia did say, I know she's this is a good question on here about the viabilities of 589s. And I will say that, the environment usually got tougher in the first Trump administration for asylums, but good cases still got approved during those years. And Congress, the president can say no more asylum, but the president can't effectuate no more asylum because Congress can only do that. It's in the statute, and this is it has to be made available. So if the president issued some executive order saying no more asylum, for example, the district court would probably overturn that in about 5 minutes because it's something that only Congress can do. On the other hand, the president is the one that hires asylum officers. And so USCIS, is under the control of the president. He's the one that, at least the political appointees that he puts in place there. So they can make things a lot harder, but they can't, there are limits. They don't have they can't order officers to deny cases that have met the requirements. But they can talk about, standards, and they can do things. And Andrew, you file a lot of asylum claims, so maybe you have some thoughts about how you're going to be approaching the next couple of years on these claims differently than you might have in the Biden years.
Yeah, the main issues with current, for the few people who are able to make it in without being apprehended, you're going to run into two major issues. The circumvention of lawful pathways, which Biden promulgated, and then the securing the border executive order, which Biden also promulgated, that tracks the daily crossings and the average over time. Those are immediate knockouts for asylum unless you can show that you qualify for an exemption. So all of your recent crossers, if you're doing asylum screenings, you have to immediately look at, does circumvention of lawful pathways apply? Does securing the border apply? Or do they both apply? A lot of the exceptions are the same. For one, if you meet one, you're probably going to meet the other. But if you don't, then you're not going to be able to pursue asylum, but you can pursue mandatory withholding under the INA and withholding and deferral under the Convention Against Torture.
All right. Similar, I mean, another question that's sort of that's the theme, and I think it's a good question, is, does reinstatement offer you any protection from being detained?
It's an important question because it does not. It does not offer that kind of protection, from being detained. And I think it's just important that is being conveyed to students.
Right. And filing a court action doesn't protect you in the direct sense, but I think a judge would be really angry if somebody was detained in the middle of asking for relief from the judge at that point. So I think it's in reality, I don't think that's something that's a risk. However,
there
was a case this past week. There's this whole thing going on about ICE arresting people that were in state proceedings. That ICE arrested a defendant. Maybe it was in a civil action, but ICE actually arrested somebody or was a witness. Anyway, there's fights going on between state officials and ICE officials regarding that. That's a different subject. We could talk about that another time. All right, so let's
say though that what's kind of interesting about it though is will we see removal proceedings in a lot of these types of cases if there is a sort of a declaration in a sense from like what you were saying before, Greg, that they're not out of status, right? Yeah. That the students are not actually out of status.
All right, so Montia had a question that's kind of a follow-up. If it was, how do you confirm a true dismissal? It'll be in the court records. It will say, there will be a court order from a judge saying that the charges are dismissed. It's not. If it happened, it will be in the records, and you would probably want to. I mean, your immigration lawyer would obviously be presenting that documentation. Let me actually. Oops, I'm going to change that banner to something better. Here you go. Okay, so back on that question, is there any, Andrew, you would just basically, the records would be presented with the adjustment application with the caveat that you just gave, which is that that doesn't guarantee you're not going to have a problem with the adjustment interview.
Yeah, pretty much. You have all your certified documents pursuant to our prior discussion on this, and your immigration attorney will have looked at the documents to confirm. That is a legal question, so it is case by case. I know that's the favorite lawyerly answer, but it's true. This is not a factual analysis. This is whether something is a dismissal or a conviction is it's a pure question of law. Your immigration attorney will have already settled that in their memorandum, which should usually, a nice little memorandum should accompany an adjustment application just to hit the high points. But if you have criminal matters, you definitely want to point out if it's a true dismissal as opposed to a conviction clothed in dismissal language where you previously entered a plea, you came back 6 months later, it was tossed. That is a red herring. That is not a dismissal for most immigration contexts. So if you have criminal issues, even if they're dismissed, it is generally not a good idea to proceed without a lawyer, but especially in these instances, you need counsel that's experienced with how to tell if it's a true dismissal or a conviction that just that's disguised as something else.
Okay.
Hey, Greg, I just noticed with your banner, you might want to.
Did I screw something up?
Well,
what did I say?
anyone, you can schedule consultations. Any of the
So
lawyers.
Adam put a link up before that was only for Adam.
I'm thinking about people who are just
Adam
joining
was like then telling me, it's like,
just he wants to dissuade.
yeah, like these are for
Don't
Adam.
want an appointment with Adam.
Take a screenshot of take your phone out and take a picture of that if you want an appointment with Adam. If you can't get an appointment with Adam because he's really far booked out, which is a problem, take a picture of that, and there will probably be.
I'm also in that link too.
Yes, you can get to Adam through this one. Also.
Yeah.
All right. So, and Andrew hasn't given me his.
I haven't.
On there, but Andrew Rankin is. Do you do consultations for people out of town?
I do. Adam, I'm texting it to you.
Oh, okay. Oops. Yeah, let me see.
I will put. Yeah, Adam has the ability to add this to as well to a banner. Let's go back to the questions while Andrew's working on that. And we had a question on applying. So this was one about the 180 days. So we were talking before about the 3 and 10 year entry bars. Until there's a revocation or an official something officially confirming that you are out of status, which would either be a revocation or it could be a denial of a reinstatement. The 180-day clock doesn't start until, because you have a duration of status I-94, until there is something officially determined about your status. It is either, even if it's an automatic, Adam, let's just say that ICE was lying and the and SEVIS, you know, they were lying in the declaration, but telling the truth on the website, and you actually, you're out of status at that point. I don't know that actually triggers the 180-day clock until there's something in writing that you get that says that you are. I remember that on the 3 and 10 year bars, it's not an automatic, like a denial. If you filed it for an F to an H change and it got denied on there, you're not automatically accumulating the 180 days from that point. There has to be some kind of determination that you are no longer in legal status, and you have to have that has to be given to you in writing, I believe.
That's true.
And then I think it would be basically the reinstatement denial might have that language, or a revocation from USCIS of your F1 status might have that language on there. But without that language, I don't think the 180-day clock starts.
Yeah, I agree with that, and I think there's been some confusion about that, just because of some things that are up on the website for USCIS, which actually have been there since the Biden administration. But as far as I understand it to be, the policy is still since 2009, has been that there has to be a decision that's made by USCIS or by an immigration judge. And that was a subject of some, during Trump 1.0, that was a conversation when USCIS was actively trying to change that unlawful presence policy for F1s, and it was permanently enjoined in the Guilford College case.
Yeah.
So I think that there's no accrual of unlawful presence. That's what my feeling.
So I just posted this comment from Stephanie Lynn, just noting that about this coordination that seems to be happening between SEVIS and the State Department on visa revocations, which is, I'm guessing that one of the lawyers that in the Michigan case might want to have a conversation with you or others that can verify, in fact, that that's happening, not just on a one-off basis, but is happening to lots of people. All right, and then Angie had this comment. about I-20s being reissued and then being terminated again because of so that goes back to that question of that strategy about just trying to start up again.
Yeah, so it's concern. Okay, so it's just concern with it being auto terminated. Yeah, I don't know. Like, I haven't actually seen examples of it actually being auto terminated again.
All right, and this person asks, is email the only way to find out about revocation?
The visa revocations coming through through Department of State to the email address that was used for the last DS-160, I want to say, for the visa. I think I've put up the banner, Greg, for Andrew, but I'm not.
Hang on, where is it? Oh, here it is. Okay.
Okay.
That all
Andrew,
right?
Can you double check, Andrew, that that's right? Just want to make sure.
It is indeed.
Okay. Okay.
All right. Take a picture of this if you need to reach Andrew. Andrew is we wouldn't have put Andrew on here if we didn't think he was a great lawyer who could who especially on some of the issues that he talked about. Mm-hmm. Great removal lawyer, great asylum lawyer, and great when things go south. He's a good person to reach out to. All right, back on the questions. So we had a this question is SEVIS when the record is terminated. That wasn't the question, but that's helpful to see that. Let's see if I apply for
yeah. So it says OPT is also terminated. Mm-hmm.
Well, the days. Wait a second. I think we answered that question. Some of these questions are up here more than once. And Patricia says in Mississippi, a dismissed case may be remanded to drawer. That sounds like a very Mississippi thing. Okay, and we had a question. Somebody in OPT preparing to apply for STEM. Can I still apply after the termination? Is the EAD card invalid? How long do they have to stay in the U.S.? So this is a question we've talked a little bit this evening about it. It is hard to say because we're not getting clear answers from the government on the way they think about it, and the courts haven't really had that much time yet.
And I mean, you need a recommendation for your OPT, but if your record's terminated, that's kind of that's part of the issue too.
So. Yeah. So I think this is one that, Adam, if we don't think that reinstatement works for OPT people, then I guess their choice is litigation. Or they work until the 765 is rendered invalid, that it's revoked. But if it's still showing as valid, the card is not expired, USCIS.gov is not showing it having been revoked, then I think the EAD card still operates. If we're listening to what ICE is saying, that it's that the revocation of the record doesn't render it. I just think that that's not going to last very long.
There's contradiction about that too, about whether that means a loss of work authorization, because their own policies say it is a loss of work authorization. So yeah, I think
they didn't say that in the declaration. They just
I know.
So I think you use their words. Mm-hmm. You take them at their word, and on there where they indicated that the person is still in invalid status, and USCIS is the arbiter of the 765. ICE doesn't determine your status. USCIS determines your status, I guess. Does ICE have the ability to declare somebody out of status? I don't think so. So
yeah, I don't think so either.
Yeah, so I'm not so sure that you can't continue working until USCIS makes a determination in that matter. Especially now that ICE says that you're not that you're still in F1 status on there. They're trying to have it both ways, and that's they're having it both ways. You can have it both ways. All right. Let's see. It affects negatively if there is so I have active supervision. I think that's a question you might want to talk to a lawyer about, because that's a pretty specific one. And the same on this one. Sorry, Montia. That actually gets us through the end of the questions. We're almost at 2 hours. And I want to thank you, Andrew, for sticking around longer than probably what he thought was going to be necessary. And Adam, hopefully we conveyed some good information tonight to people. Adam has do you have any sort of further sources places people should go to for information generally? Obviously, we have our live streams on Wednesday nights. I don't know if you have well, Adam, we didn't plug your book, which is awesome on here, but the book is called The Academic Immigration Handbook, and you can find it on Amazon, and that is by Adam Cohen. So I would highly recommend it. And with that, I will bid everybody good night. Thank you.
Good night,
Adam and Andrew, hang on a second after this ends.
Sure. Thanks, everyone.
Bye, everyone.